back here live from the fortified compound in Mesa, Arizona. We're going to do our best to get through a show without any tech issues, but we're not promising anything. It was I had actually just posted a few minutes ago, well, about 10 minutes ago, that it was not going to be a live broadcast today. But as bad as things are right now, at least we're able to do the show. So we'll take this as long as we can. So I'm going to try to get some better video. So this way, if we are able to get the better video, then I'll post that at markstevens.net and also on the YouTube channel. If not, we're going to get stuck with the glorious 360. But hey, the strength of the material is not moi. Although I would like to point out that we are now Illuminati certified. So all you conspiracy theory guys who happen to listen to the show, and now you can start going on about. You should see the back of the shirt. It's got the all-seeing eye above the thing. But I appreciate everyone tuning in. I'm not going to even say what episode it is because I had so much trouble just getting the show ready so that we could be on the air that I did not look up which episode. I think it's episode 13, but we'll get that in the show notes when we're done. But if you want to join me here on the big show today, you can do so. The number is 632. Let's see, what do we got here? Wow, that's not right. Let's get there. It's 632. Well, 218-632-9399. 218-632-9399. Skype is Frank Rizzo 3. Frank Rizzo with the number 3. Yes, it is a Jerky Boys reference. So, again, if you want to join the show, 218-632-9399. Now, barring any tech issues, we already hit the ground running here on the No State Project because we've got Casey in Spokane. I'll get that up in just a second. If you are interested in learning how to effectively defend yourself against bureaucratic attacks, man, that's what we do here on the show. So if we have the time, then one of the things that people have asked me to go through is the procedure. What the hell is the procedure when we file the motion to dismiss, and then do we file this, do we file that? What do we? How much time do we wait to file for a motion to dismiss for prosecutorial misconduct? I'll go through all that stuff again. If you go to markstevens.net and you do get the package, the motion to dismiss templates, the instructions are there. Apparently, they're not clear enough for everyone, or maybe they're not comprehensive enough, so I will go through that. But without further ado, let's bring up KC from Spokane again. KC, welcome back to the No State Project. What do you have for us today?
Hey, Mark.
Are you kidding me?
After our last talk,
Casey, you're live on the No State Project.
Sir.
Yeah, there he is. Hey, we got him.
Hey, so after the last time we spoke, I filed an updated Brady request asking for the name of their witness with firsthand personal knowledge of the application of the codes and Constitution to me. And what they sent me back was basically a thing saying, hey, we've already given you everything we're going to give you.
Okay.
And a request, a discovery request to me.
To you?
Yeah.
Did they forget that this is a criminal proceeding?
Yeah, I guess so. I had to read it twice to look and say, okay, yeah, the state is actually sending me a thing that requests for, I had to read each line, defendants, witnesses, defendants, this and that. And I'm like, really?
Well, that I could see. Okay, as far as that, you're not planning on calling any witnesses, so you don't have to provide anything. The only thing that you could put on there is that you do plan on possibly recalling the prosecution's witnesses, but I don't think you even need to put that in there. You're not calling any witnesses yourself.
Right. Yeah, and so I didn't have anything to give them, so I didn't send them anything.
I don't like playing it necessarily that way. I think it's probably better to take the high road and just send them a letter saying, I don't plan on calling any witnesses other than possibly recalling yours, and leave it at that. Okay.
Duly noted.
So now let's go over this, what they're saying here, because this is what I was just mentioning about something being ripe for a motion to dismiss for prosecutorial misconduct. If he's saying he's given you everything, there's a number of issues we have to go through here. So I don't want to forget this. No witness. This is something I was doing a consult with someone just today about regarding what the prosecution has to give you. I think it's right for the motion for misconduct, and you can use his own statement against him that He's saying he's given me everything, but there's nothing in what he gave me that even remotely resembles evidence that just because I'm physically in Washington, that your magic constitution and laws apply to me. So they're arguing without evidence.
So I'll do you one better. I brought it up in our motions hearing last time. So we have already filed once a motion for dismissal for prosecutorial misconduct for failure to show evidence.
Great. What's happened
when
with that,
when I go ahead?
I'm sorry, I was interrupting. I was just asking what happened. I think you were going to relate to us what happened.
The judge denied it, and this is when I threw you the comment the other day. The judge assures me that the Constitution and codes apply to me, and when I start asking him to the nature of those, it went everywhere until he got angry enough to tell me to be quiet.
Oh,
so he told me that jurisdiction applies because I showed up. So I explained to him that I was only there under threat and duress. And when he said I was free to go, I said I'm free to go without repercussions. He said yes. I asked him again. I am free to go without any repercussions, reprisals, or violence from you. He said yes. I said if I walk out of here, you're not going to issue a warrant. And he goes, oh no, I'm going to issue a warrant. So then we got back to okay, so I'm not here of my own free will. I am challenging your jurisdiction, and it is your position that jurisdiction applies because I'm here. Is that correct? Yes. And then they actually gave me a statement at the end of the whole thing that basically says, we have jurisdiction, and that's that. And it was always the judge taking the argument. He told me to shut up before I had a chance to ask him if he was taking the prosecution's burden.
Okay, I want to point out, I think what you did is fine, but there's a much more effective way of going about doing it. You
Please
remember
help.
You gave the judge fits. You're doing pretty good already there, tough guy. You want to keep in mind, you want to be objecting, and you're only asking questions, right?
Yeah, that I've got a problem with. I've got to I got to use your tactic of it is your position that. So that if I end up making a statement, it's still a question. Is it your position that the following, yes or no?
Yeah, and because what's important here is you want to be able to show that your physical location in the courtroom, just the fact that you showed up, is not evidence that the Constitution and Code apply. And you want to be able to, you want to take that away from them. And the way we do that is by asking them, let me see if I understand you correctly. You're telling me your only basis for jurisdiction is that I'm here. Yes. Okay, great. So if I never showed up, if I completely ignored your process, you'd have no jurisdiction to issue a warrant for my arrest? Then they'll correct themselves. No, we'd still have jurisdiction. Objection. Doesn't that mean that my physical presence here is completely irrelevant to whether you have jurisdiction or not? And that's how you go about gutting their statements. Yes, you're right. We're asking clarifying questions. Is it your position? Because that's very important. We don't want them to say, oh, you're taking me out of context. Oh, you're twisting my words. We ask the clarifying question so that when they say something like that, they're exposing themselves as the idiots and criminals that they are. No, you just said that my physical presence here is what gives you jurisdiction. So we want them to...
And like I said, We got a number of those out, and enough to where the people that were still in the courtroom were looking around like, wait a second, didn't he just say that, he's not there under threat, and then that guy immediately said he'll issue a warrant for him?
Well,
people are looking around like, you start hearing little murmurs. Wait.
Yeah, well, no wonder the guy's getting mad, because you're making a fool out of him in front of a whole room full of people, but he forced you to be there. He is forcing your hand. He is not only forcing you to be there, but he's saying things that are so contradictory that it only takes a few questions to bring that out. So no wonder he's getting mad. All you did was try to get him to verify his position. So of course he's going to get mad, and he doesn't want you to infect the rest of the herd.
He managed to win, though. Because he got me. He ended up catching me on the when he basically when he said, I assure you that the codes and constitutions apply to you. It's the law.
Okay.
He didn't give me a chance to even respond. Like, I objected, and he just said, your objection is noted, and told me to be quiet.
Oh, because for those, I'm sure this is probably where
And
we're
honest to
going.
God, the standby counsel kept telling, every time the judge told me to be quiet, standby counsel told me to be quiet too. Even though I kind of knew in my gut that I should continue to be objecting and pointing out that there's fallacies here.
Well, right, because the proof by assertion fallacy is what we're getting at here. Because when he says, I've said this on the show, I don't know, so many times, because it constantly comes up. I say it on almost every single consult that I do. They always will snap at you. I assure you that this court has jurisdiction over you. And its objection is that because you said so or because the prosecution's evidence does. That's the big question.
I asked for the evidence, and that's where he just laughed. And I asked if the prosecution had facts and evidence, and that's where he just kind of chuckled and said, "It's the law." And I was the next thing out of my mouth was the next question was, "Are you taking the burden of evidence? Are you taking the burden of proof for the prosecution?" And he didn't. He shut me up.
That's a fine question,
I gotta,
but not right there. It's always, I know that you're saying that the court has jurisdiction. You're assuring me. Is that because you said so or because the prosecution's evidence does? You have to separate the two before you could then move on. Because now, if he says the prosecution's evidence, sir, I'm more than happy to plead guilty right now. What is that evidence? Now, if he turns around and doesn't disclose it, it's a real problem, because now you've got a judge who is knowingly concealing evidence. And concealing evidence, that's the thing. That's why it's so important to get them to agree to these and to what's going on, and get and making it specific that it's the prosecution's evidence. Because if he doesn't disclose that to you, you cannot defend yourself. If you can't defend yourself, it's unfair. So if we have to file a motion to change the judge, you have to show a bias or prejudice that is so great that it denies you a fair trial. Now, not being able to see the evidence and willfully concealing the evidence so that you can defend yourself is a denial of a fair trial.
Certainly unfair.
Yes. And so when you go to change the judge, and you can't change the judge after he's made the decision just because you don't like it. Generally, no, just adverse rulings are not grounds to change the judge, except if it demonstrates a bias that is so great that a fair trial is not possible. So when he says he's basing his decision off the prosecution's evidence, and you're asking for what that evidence is, and he will not respond or have the prosecution respond, then they're concealing evidence. That is a bias on behalf of the prosecution, and that is a bias so strong you can't get a fair trial.
And say it's the if he turns around and says it's the officer's testimony, what do I reply with?
What is the officer testifying to that would constitute evidence proving the Constitution applies to me because I'm physically in Washington? Put it on the table right now, and I'll plead guilty.
Okay, that was the wording I didn't, because my mind kept trying to angle me towards his qualification for making legal determinations. But at the same time, I'm like, no, that's not the angle.
Well, at this point in time, the prosecution's burden is not beyond a reasonable doubt. It's a prima facie, which means he doesn't have to present the actual evidence and give you an opportunity to challenge it. He just has to tell you what it is. He has to tell you who the witness is. He doesn't have to go through the credibility and competency of the witness at this point. That's something he has to do through the Brady request. Once you file the Brady request, now he's on the hook to provide you the competency and credibility of the witness, and to give you, through discovery, he's supposed to give you the evidence he plans on bringing out in his direct examination and what he plans to present.
And that's what we did. We filed the Brady early, and we also filed the amended Brady because they hadn't answered that initial question in the first place. So we've asked for it twice, and they've said we've given you everything we're going to give you. And what it is the officer's testimony, the testimony of the nurse who drew my blood, and that's it.
Well, okay. He's telling you who the witness is that he relies on, but he's not. This is one of the other things that I wrote down. He's not.
Yeah, and I think that's what he was doing. He's keeping me confused as in, no, here's your witness, but I didn't realize I had to ask, now, what is the witness saying that provides the evidence?
Right. It's not enough to just say the witness against you, Casey, is Officer Douchebag. This is discovery. He has to tell you what the officer is planning to testify to. It's no different than if you were making an affirmative defense that you were not guilty by reason of mental defect. You have to present a list of the evidence and the witnesses and the evidence that you plan on providing to the court to make your case. So the prosecutor has to do the same thing. You don't just, I'm going to prove that so-and-so is guilty of murder, and I have 12 witnesses to prove that. Okay, are you planning on, what are they going to testify to? Where were they? You have to,
right. Did they see the act? What did they see? What's going on?
Right. So this goes to this nonsense, and there's a prosecutor in Ohio and I'm going through this right now. He keeps insisting that I'm cherry-picking Rule 602 that says that no witness may testify unless evidence is introduced to show that the witness has personal knowledge. The second half of it is that personal knowledge can be brought out on the witness's testimony. I understand that. We get that. But in the discovery process, and we can't forget about Brady. This is very important. We'll get to that in a second. In the discovery process, you have to disclose what they're supposed to be testifying to. You don't have to give every jot and tittle. You have to give us an understanding, an idea of what they're testifying to, so there's no surprises. That's why whatever is not introduced in pretrial is not permitted to be brought up at trial unless there are extenuating circumstances. Let's just say the prosecutor says, you know what, this just came across my desk this morning. I gave it to the defense, but I couldn't give it to him 6 weeks ago. I didn't have it. Then it's still up to the judge to determine whether it's proper to have it or have a recess so that you have an opportunity to go over that and learn how to, and frame a defense to whatever evidence they may have. So something like that happens like My Cousin Vinny. We'll keep going back to My Cousin Vinny there. They had the expert.
He has to give it to you. It's disclosure.
Yeah, it's just called disclosure, you dickhead. They didn't teach you that either. So they did have a surprise at the trial, and the judge allowed it. And so Vinny had that great objection that he needs some time.
That's the part where he says that was the most articulate thing you've said, overruled.
Yes, because it's an expert testimony, and he needs time to go over the testimony and the evidence so that he can frame an actual defense to that and, an adequate, effective cross-examination. Of course, the judge denied it, but he still prevailed because he was such a smart guy. These guineas like myself. I actually got accused of being a racist because I referred to Joe Arpaio as a guinea bitch. And I said, I don't dislike Joe Arpaio because he's a guinea. I've been called a guinea all my life. I'm half Sicilian. I don't like him because he's a vicious criminal. And the fact that I was sexually molested by one of his officers gives me every damn right to call him a guinea bitch since he didn't do a damn thing about it. I wasn't raped, and it was a woman. That's all I'll say. But
sexual assault. Sexual assault
is sexual assault. It's the only time I've ever hit a woman, and she deserved it. She does.
Another interesting thing, we put in a motion. So the judge put in a not guilty plea for me. Okay. And we put in a motion to strike that, and he basically said, so if I grant this motion for you to strike it, what are you going to do? And I let him know I intended to plead guilty. I have my unsigned plea here. I just need the prosecution to provide the evidence that the Code and Constitution apply to me just because I'm in Washington State. And that's when he went into his tirade about, let me, I assure you it's the law. But needless to say, he denied the motion.
Sure.
So there's still a not guilty plea that was put in on behalf of apparently by me, but by somebody who doesn't and never did represent me.
Well, the important thing there is that the judge lied because you're trying to plead not guilty and he's pleading guilt. You're trying to plead guilty. You just want to see if there's evidence to justify forcing you into these proceedings. He's lying for the prosecution, covering his lack of evidence by saying that you're refusing to plea, and then he pleads not guilty for you. So that's why
we are actually yet to bring out the refusal to plea part. He when I asked him, or when I start to get into that line of in terms of, this plea was entered by, on my behalf, and I, this wasn't a consenting plea entered by me. I have a plea that I wish to put in fully, knowingly, assuming that, again, the prosecution can provide the evidence that's been requested now 3 times.
Yeah, well, you still...
So, like, every one of my motions have been denied. The motion to remove the plea, the judicial misconduct, and the motion to dismiss due to lack of evidence of jurisdiction.
Okay. Well, did you file a motion to reconsider, or did you file a motion to change the judge?
No, and actually, those are both things that I would like to get in there before the end of the week. That was part of the reason I wanted to get a hold of you, is to go over some of that documentation with you, because so far all they've done is recycled. Like, even when I asked again for the motion for lack of jurisdiction and the amended Brady, they keep just coming back and saying, here's the testimony that he's going to give, this is what he's going to testify to, and it's just it's the same generic stuff.
Well, I would certainly move. Yeah, I would say, move to get him disqualified, because that's, if you wanted to, like, and we're doing this in Louisiana, so it's my first time in Louisiana, so we'll see what happens. It gives you grounds to stop the trial court in the higher court with a petition for writ of mandamus to review his...
For writ of mandamus. I was wondering about that, if there was something I could do in the Superior Court that could stop these current proceedings. That's good to know.
Yes, I will tell you, we've had absolutely zero success with stopping a trial in the federal court. 100% of the time.
No doubt.
Yeah, 100% of the time, the federal courts, regardless of the law, their own rulings, that a denial of a motion to change judge is grounds to stop a trial and have and take jurisdiction for the petition for writ. 100% of the time, the Court of Appeals is not allowed to go. And in some instances, it was like a $500 filing fee that's gone. At least, I give them this in Maine. In Maine, you pay $200 for a filing fee, and they tell you to go F yourself. They ram the money down back your throat. They give the money back when they refuse to take jurisdiction.
They force it back to you?
Well, I don't say they force it, but I look at it that way, because you're desperately trying to stop some lunatic from harming you, and they have the authority to stop it, and instead of accepting the money and at least giving you temporary relief, they send the money back. And what's $200 or $300 to these people anyway? So,
this is where those crazy sovereigns get the idea of doing those liens and crazy crap like that, is exactly this. Like, even if you try to get the higher court to say, whoa, like, look, there's an obvious conflict. This judge has put in something on my behalf. He will tell you himself he didn't represent me then, he doesn't represent me now, and he won't represent me at trial. So he won't let me put in a plea of my own free will. There's an obvious problem here.
Yeah, I still think that the better way to go about it is to show that the judge is lying on behalf of the prosecution. I think that is 100 times stronger than the other one.
Certainly. And again, why I come to you with these things.
I appreciate that. So the petition for writ of mandamus is at the state level. We've had, not that we've had judgments always in our favor, but we have successfully stopped the trial court most of the time. So in Arizona, for myself, it's called a special action, 100% of the time I ask them for a stay. I've gotten it, and that the one that was most stressful was a few hours before my scheduled trial in the Mesa City Court. They wound up faxing a copy to them, telling them to take the afternoon off, which was kind of nice. So at the state level, we've almost always gotten at least the trial court temporarily stopped. So that usually is all we need to then eventually have the prosecution withdraw. So you can contact me for that. I have templates for that. I want to point out something very important here, and I'm going to keep repeating this because it's so important. People seem to be missing this. The other part about the witness, if you're asking the prosecutor for the name of a witness with personal firsthand knowledge that the Constitution and Code apply to you because you're physically in Washington, I don't think it's sufficient enough for him to say, this is all we have, these are our witnesses. I would get back with him and say, I need you to spell out exactly what you mean by this. So because of, I don't remember what it is. Let's say it's point number 5. In point number 5, I'm asking you, maybe you can tile it an addendum and request for clarification. I asked you who the witness was with personal knowledge or Constitution laws apply, because I'm physically in Washington. Do you mean that officer so-and-so is that witness? And if he is, please be extremely explicit that this witness is who you rely on with personal knowledge that your Constitution applies to me because I'm physically in Washington. I want that spelled out.
That's exactly what I want to do. That's precise, especially when they sent me a discovery request. That's precisely what I want to do. Turn that around and say, no, in no uncertain terms, tell me this is your witness who's going to make this statement and that you believe that's qualified.
Right. And we would be expected to do that. Mark, you totally need to tell us what your witness is testifying to. And if he is, and we want to see his qualifications. I can guarantee you that they want that.
In fact, the Brady that they sent me does say that. The discovery request they sent me does say exactly that. We want to know all of your witnesses and what they're going to be testifying to.
There you go. There's your double standard. They have to disclose that to you. It's
actually, it almost looks like they copied and pasted yours and replaced defendant.
I don't. Well, a lot of what I have, I got. I copied and pasted from a lawyer too. So that whole thing. I didn't write that whole thing. I wrote parts of it. Some of it was freely available a number of years ago, and I just took that. It was easy. I mean, I changed some of the wording, but the general idea on some of those points is what any rational, defense counsel or McKinsey friend would ask on a discovery request. Let me give you an example of what was done, and it really helps to do. You need to do this because they're going to contradict themselves. Because we know damn well, no matter how hard that attorney fights against your objection to, about the qualifications for that police officer to be on the stand, he will fight you tooth and nail to get his butt in that seat. And we know he's going to contradict himself. So it's very important to get him as explicit and as clear and specific as possible. So when they did this to me with our friend Bill up at the Twin Mountain Country Store, and I urge everyone to show some love up there and call into shows like Free Talk Live and let them know that is just a horrible situation what those agencies are doing, admittedly without evidence. But what one of the attorneys did, I objected to his witness on the stand because I had already spoken to the witness. I was already denied disclosure. But I had already spoken to the witness. I knew he wasn't qualified. I had already cross-examined this particular witness. So when they tried to put his butt on the stand again, of course I objected. I gave the whole history. So what this lawyer did, he says, I am making an offer of proof, Your Honor. You're making an offer of proof. So what would you do in a situation like that? You're in court, the judge is sitting there listening to this, to you saying that the witness isn't qualified, he doesn't have personal knowledge, the prosecution has not given the discovery, and the prosecutor says, Your Honor, we're making an offer of proof. Can we now have the witness testify on direct? What are you going to do there?
I have no idea how. No idea what I would be doing there.
You see, that's why we do the show. Shouldn't the first word be objection?
Yes, it absolutely should.
Okay.
And listening to the show as much as I do, I should certainly know that. I guess more of the point is, even if I objected, I'm not sure what I would state next.
See, if those who are listening to the show or who are watching this, and when you watch this, you're going to be like, oh, man, I can't believe that. He already gave the answer like 3 times. You want him to be extremely explicit. Are you saying in front of everyone right here, right now, that this witness has personal knowledge that the Constitution applies to me because I'm physically in Washington? You want him to be very explicit because you know damn well once you ask his witness 2 questions, and I'll say it again. Did you determine on your own that just because I was physically in Washington, your Constitution and laws applied to me, and you had jurisdiction to stop and give me a ticket? Stop me and give me a ticket. Yep. 2, officer, what evidence did you base that determination? And that's when they're going to impeach their own witness. This gets to why Brady is so damn important. So when they make an offer of proof before you want them to say, I'd love to have it in writing. My witness has personal knowledge of this. Great. Then when you ask that second question and he objects, calls for a legal conclusion, the witness isn't qualified to testify or outside the scope of his expertise or some other similar crap, you can point out.
Motion to strike.
No, would you say, excuse me, I think maybe the prosecution would like to get some advice of their own counsel. Do you realize? I said, maybe I'm wrong here. Didn't you just testify before that your witness had such personal knowledge and was qualified to testify? Didn't you just say that with your offer of proof?
Oh, gotcha.
Lying snake. Anything to put that damn cop on the stand to say the very little he has to say so that he can get 12 people who don't know any better to deem you to be guilty of something. And it won't matter to these people that their own witnesses declared incompetent. And this is why Brady is so important, because you're setting up something that the prosecution always does. He will go gangbusters to get that cop on the stand. Anything he has to say and do to get his on the stand. And once you hit him with a difficult question, he's going to impeach his witness. Why didn't you? You can even say, why didn't you tell me in discovery? Why? I said, this looks like a Brady violation, sir. If you knew your witness wasn't qualified to make legal determinations, you were obligated to say that. That's going to happen. I can almost guarantee.
Isn't that the basis of the prosecutorial misconduct?
Absolutely. He's not only arguing without evidence, he knowingly put a witness on the stand that wasn't qualified. Oh, how do we know he's not qualified? Because the prosecutor said so, and the judge backed him up. Because your determination means absolutely none. None. No one gives a damn about what you and I have to say about whether the cop is qualified or not. But when the judge sustains the prosecutor's objection on his own witness, that means something. That carries weight. Oh, what is it? That's the law of the case. This witness is not qualified. Which is why, as we know, and I'll get it posted this week, Jermaine, they've not refiled against Jermaine in Calgary on his mistrial.
So does that mean that it's just hanging?
As long as they don't refile it, he is out of jeopardy.
Yeah, when you say they haven't refiled, so that means that what's the limitations on that?
I don't know. I don't know under Canadian law what they believe the time frame is to refile against him. I would imagine they have 30 days to file. It's not a murder trial. It's not like something that would require months or even a year worth of prep work for a team of lawyers to do. No, this is traffic. This is simple. This is a marijuana charge. They should have refiled. If they were going to refile against him, they probably would have done it the same day or the same week. So right now,
certainly,
it operates right now as the same as a dismissal without prejudice. It's a dismissal without prejudice.
Yeah, I was going to say without prejudice.
So whether they decide to but then if they refile it, they're going to have the same witnesses that have already been deemed to have lied. So the act of filing against Jermaine would be considered an abusive process. Prosecutorial misconduct. It doesn't matter who we are. Whoever files the complaint, the rules hold. These are some of the common sense ones I think we would all agree to. You have to do a reasonable investigation to determine whether the facts are correct and the witnesses are competent and credible. It's not supposed to come out at trial. I mean, it does, but it's not supposed to come out in trial that your witness is not qualified. That's what the pretrial process is supposed to do. The pretrial process is supposed to whittle down the issues for trial, the issues of fact for trial, and whether that you have competent, credible witnesses to be able to go to trial. So before anyone turned, hey, he just said this is a fact. Whether a written instrument from 1892, whatever it is, applies to Casey today, just because he's physically in Washington, requires facts, requires evidence. So pure issues of law that require no evidence are theoretical, purely theoretical. Is arguing without evidence prosecutorial misconduct? Yes. Absolutely. You just have to look at the law. Is prosecutor A guilty of prosecutorial misconduct? Well, that requires evidence. Does a written instrument from 200 years ago apply to KC now just because he's physically in Washington? There has to be evidence. It's a written instrument. That's all it is.
Same standard.
It's the same standard as any other written instrument. And it doesn't matter if someone says, but Mark, it's a constitution. It's not just a written instrument. Really? What else is it but a written instrument? You can't turn around and say logically that the people agreed to that because they are forced to pay. But to get back to here...
Well, yeah. It's not even a matter of law of contracts because the violence is still there. Like, free market is truly the law of contracts.
Yeah, and anytime you use...
A real free market.
Well, right. I get what you're saying. Yeah, and because they are just men and women forcing us to pay them, that negates any kind of claim of a social contract or that you agreed. There's violence.
Yeah, no duty, no obligation.
Yeah, right. So here, to get back, it is critically important. Everyone listening or watching the show, keep in mind that the Brady material is extremely important. Extremely important. And it doesn't matter. If you're in Canada, they are still required to do it. And I think we brought out on the show a few weeks ago, Casey, that it's Rule 29 and Rule 24 in Australia that they have to have they have to have evidence to support their claims.
Now, the Canadians are based on the Queen's, the Crown law, and so do they have a Brady equivalent? Is it a rule or is it also a ruling?
I don't remember it off the top of my head, but yes, they have to give what they just use the I think I do have a case citation. I'd have to look it up. I can't get it right now during a broadcast, but they have to give, whether in England or the UK. Australia, New Zealand, or Canada, they do have to give exculpatory evidence. And that's what Brady material is. Brady material is exculpatory evidence. Brady was just the name of the case where they were restating a rule that had already been in place.
That's like everybody referring to Heller.
Yeah, or Miranda.
Yeah.
That's just how we identified that particular case and what they were holding. So I give no quarter. I think, this idea that the police officer is not there to testify and give legal opinions, I don't know how many times I've said it. It keeps coming up. And so we have to keep addressing this because new people are listening to the show. Cross-examination is not limited to just what was said on direct. And anyone who tells you that is lying to you. Because, look, I know it's getting a little long in a tooth now, but you refer to very high-profile cases like the O.J. Simpson trial. They put Mark Furman on the stand as a witness to what happened after the fact and what was found at the scene. They were, on cross-examining him, they were going back to statements he made 10 years ago because they were trying to show that what he presented was due to bias and prejudice so bad that it tainted the evidence. So cross-examination is limited to things that are relevant to showing or challenging competence and credibility of the witness. All of his prior statements regarding what he did to you, Casey, all of them are on the table on the cross-examination. So let's say he called you a dago at the stop. Just because it didn't come out on direct doesn't mean you can't ask that on cross-examination.
I also find it fascinating that I have this testimony where he, regardless of the state of the case, factually speaking, there's a number of very large discrepancies in the stuff he says. So, like, he says in his statement that he asked me if I wouldn't mind taking a sobriety test. If I had known it was an option, I would have told him to go eat it.
Well, what you have to do
it was not presented as an option.
Yeah, but you have to ask.
He told me to get out of my car and to do these things.
Well, they have to look at the totality of the circumstances to determine whether it was voluntary or not. You can ask him point blank, if I don't do this, what is the result?
The consequence.
The consequence.
Certainly.
And he can tell you.
And this is important for anybody listening. Like I've been listening to you for 2 years now, or maybe even a little longer. And like all of the court stuff is great, and it certainly helps. But there are some things like this now where you don't want to argue with a cop. He has a gun, but at the same time, if anything you say can be used against you, you might as well get some of this opening stuff out.
Yeah, but a lot of stuff is going to, is just going to be, they're not going to include the whole thing. So it's best if
yeah, and that's what I find interesting. There's no video or audio. It's literally just his word against mine. There's nothing else to it other than what he said and anything I might say. And I'm not going to say anything but ask him questions. So it's all down to that.
Yeah, what the police officer the most he should say is, he asked me what the consequences, if any, if he did not get out of the car, and I told him. Other than that, he kept his mouth shut. This guy didn't say a word. And that should be all he...
Yeah, there you go.
That's all.
What happens if I don't do what you ask or I don't answer questions? Yeah.
And he'll tell you. And look, you can't talk your way out of a ticket. If you're going to get so keep your mouth shut. Don't argue with a 5-year-old child who has a gun. And I say 5-year-old child because you're dealing with somebody who has 5-year-old emotional coping skills. Well,
it's funny because I failed the sobriety test because I was fearful, literally, for my body. Because the last time I had an encounter with an officer, the officer was asking the driver for their information, and he looked at me and said, "What about you?" And I didn't say anything. I just kind of cocked my head like, what is that even supposed to mean? And then I was yanked out of the car and assaulted. Like, threatened, hit, like it was crazy. So yeah, you're exactly right. It's a 5-year-old with a gun.
Yeah, 5-year-olds don't like being challenged. They don't like being questioned. And if you ask, and they deal.
In this case, I looked at him wrong. His entire testimony revolved around me looking at him wrong.
Sure, that is enough for contempt of cop. Looking at a cop wrong.
Yeah.
Absolutely. And I say 5-year-old because 5-year-olds don't have coping skills. They don't handle situations where they're not getting their way. They're like a little baby. A baby doesn't get fed on time. Their only option is to get upset and cry. They can't communicate any other way. So the cops can't communicate properly.
So the situation was the driver was the driver and I were parked in our work parking lot. We worked together, and the officer came over and was citing him for something. Anyway, so he yanks me out and assaults me and everything, puts me in the back of his car for about an hour, and then because he couldn't find anything, he came back and said, "Hey, I'm going to ruin your day." And he cited me for criminal. He cited me for a couple of criminal things that were like ludicrous on their face. I was sitting in the passenger seat of a stopped non-running vehicle, and he charged me with vehicle operator non-compliance.
Well, the cops have a very common saying: "You might beat the rap, but you're not going to beat the ride." They're
exactly. They're just doing it because, like this. Even if they drop it, it's been almost a year that I've been dealing with this. The last time in that instance that I'm talking about, it went 9 months. We went through 9 arraignments, and then finally the prosecutor just came up and said. They gave me basically a year-long scheduled continuance that was basically a dismissal without prejudice, saying if you don't get in trouble over the next year, we'll leave you alone.
Sure. Well, that's a common one, too. But, the easiest way to avoid a DUI, I tell everyone, I told someone just today, he wasn't a DUI, though, but don't drink. Do your liver and your pancreas a favor. Don't drink. I lost an uncle. And yeah, I know he had reasons for that. I get it. His entire company was wiped out in Korea. He was the only guy left. There was this big parade for him in Brooklyn when he came home. You don't recover from that. So I understand the drinking. But he died at like 58 or 59 years old because the drinking just killed him. It led to, he lost his leg, he lost toes, he lost teeth, he lost his hearing. It destroys you. So,
to be fair, I don't drink. It's a good message all the way around. That's not what I got in trouble for. I got in trouble because it's alleged that my car smelled of marijuana. Nothing was found in the car, no paraphernalia, no drugs, no anything. I failed the walk test because, again, I literally was shaking with fear. I was scared to death I was going to get beaten again by a cop.
Oh, I understand. I never wanted to go to Arpaio's Madison Street Gulag ever again. It wasn't the people in there I feared so much. It was the cops.
Yeah.
It was the cops. Hey, I was sexually assaulted right in front of my wife. And you want to talk about sadistic? They threw me up against the passenger side door where she was sitting. And that's when the cop did her reach around and started handling me.
Huh.
Yeah.
That's just a dominance thing.
Yeah, yes, it's all about dominance.
No, and I mean that in a disgusting, like, dog on dog kind of way.
Yeah, there's
That's
like
lower
nothing
than
you can
bullying
do.
somebody. That's like downright dog style.
Yeah, and if to think we were in Mesa, Arizona, it's always been open carry. My wife could have had a gun. She could have turned around and said, "Not today, bitch. Not today. I'm not going to sit here and watch you do this to my husband." That you don't know. But this was somebody who we even heard the other cops making fun of this woman. She was short, grotesquely obese. She never should have been on the police force. They shouldn't. She was at least 85 pounds overweight. Couldn't have been more than 5'2". And she's grabbing me. And yeah, this is somebody who had a serious inferiority complex, was a serious bully. And probably the only satisfaction she got in life was being able to bully people out on the street. The DPS, it was Department of Public Safety. It happened on 60 and going, in Mesa, right around Mesa Drive and Stapley. So, yeah, bad stuff. But I wanted to get. Did you have any other questions? Because I wanted to.
No, and I'll catch you tomorrow for some documentation talk. I appreciate the time, and I'll take the rest off air.
Okay. All right, appreciate the call. My name is Mark Stevens. We're talking with KC in Washington. My gosh. I'm going to leave the call line up there just in case there is another caller. It doesn't. It's not. I know I was getting some notifications that there was some fuzziness on the calls. I'm not getting that, and so if the recording for the Ustream is so bad, then I will not post that today. I do have some really good video going. My usual camera is going, so we'll have the good audio there. So look for that. I just can't do it within an hour of the broadcast. So if you get the motion to dismiss package, it comes with the discovery request. It comes with the proposed plea of guilty, and it also comes with the motion in limine. I know, it's a motion in limine is how we're supposed to pronounce that. Sorry. Really sorry about that. I thought that was over. Apparently it is not. But motion in limine, what the hell is this thing? So you're filing it together with the motion to... You're not filing it with the motion to dismiss and the discovery request. It is what we do about 21 to 30 days after we have filed the discovery request. When they have not presented the evidence, if they have not presented the evidence that we are requesting in the Brady/discovery request, then we file the motion in limine. What the motion in limine does is limits what a party can present at trial. So, for example, in the Avery prosecution, the prosecution filed a motion in limine, and one of the things that they wanted the judge to limit the defense on was the defense was not permitted to argue that the murders were done by somebody else. They couldn't even present the evidence to show. So talk about a rigged game. That judge should be spending the rest of his life in prison. All of his assets should be seized. The man is just wow. I can't. That should have been one of the big highlights of that at least that part of the show, the movie, the documentary. I don't know, because they never said that if they appealed the motion in limine. How in the world, if you've got relevant evidence to show somebody else did it in a murder trial, and you can't do that? Whoa. The fix is in. It's idiocracy in a murder trial. Legitimately, idiocracy in a courtroom in Wisconsin there for the Avery. You can't argue and show evidence that somebody else did it. You can't do that. Oh, my gosh. But the evidence, it has electrolytes. Does that help? Oh, my gosh. So if the prosecution isn't giving the evidence to support an element of the crime, they shouldn't be able to argue that element of the crime. That's just common sense. If you are going to make an affirmative defense, let's say of insanity, but you have no evidence to prove that, then the judge rightfully can limit and say you cannot discuss a defense of reason by mental defect because you don't have any evidence. We see it work. Technically it works the same way for the prosecution. If the prosecution doesn't have any evidence to support an element of the crime, they shouldn't be permitted to argue it. Do they have any evidence that you violated the code? Well, they have to have evidence the code applies in the first place. But Mark, it does. Do they have any proof? That's the question. It's not because I'm an anarchist. It's because of logic. That which can be asserted without proof can be dismissed without proof. End of discussion there. Because if you persist, you're a criminal. And we have every moral and ethical justification to put that animal down. It's because I say so. Well, Mr. Glock says otherwise. You see? Mr. Glock says otherwise. What's the phrase? God may have created man, but Sam Colt made him equal. So that's what we do with the motion in limine. But wait at least 21 days before filing now. You have to give the prosecution an opportunity to respond. And in Casey's situation, it's like most of the situations, there's not going to be any evidence. So you have the motion in limine. You also have the motion to dismiss for prosecutorial misconduct, which those motions are a lot of the same. So let's go through a little bit more of this procedure. The motion to dismiss should come first. The motion to dismiss and the discovery request. Yes, the discovery request is technically premature. I'll give you that. But it's still filed. You know what I want. The Brady request is not premature. As soon as the prosecution files their complaint or their indictment, that starts the clock on Brady, and that continues even after trial. So if there's newly discovered evidence that the prosecution had or should have had and did not disclose to the defense that was exculpatory, that was material to showing your innocence, material to showing that the witness is not qualified or competent, then it can be shown, it can be brought up in your appeals or a motion for a new trial because you have newly discovered evidence. So Brady is a continuing obligation. Don't forget that. Very, very important. I actually spoke to a prosecutor that I know here in the Valley, and he was saying, man, that's right. Brady is one of the single most important things for the prosecution. He says, you can have a beautiful prosecution. Have a Brady violation. The whole thing gets thrown out. Yeah, I know. But you got these people out there. They don't want you to put so much importance on Brady. But damn it, you can't underestimate the importance of that. We have a few more calls. We'll do the best that we can to get. We could probably go a little bit over since we don't have hard breaks here on the No State Project on Wednesday. Okay, we've got Bill in West Virginia. Bill, what do you got for us today?
Hey, Mark, I just wanted to give you a call and let you know that my case was dismissed today.
Holy crap.
So it's another win for Bill.
Holy crap, that's fantastic.
It only took since November 15, 2015, but hey, you just fight the system and you stand up for what you believe, it should go your way.
Well, give us some details.
Well, all the way up till last month, they kept sending me to court. I had 3 pre-trials. This was going to be my 4th pre-trial today. But the prosecutor recused herself last month from the case. So the case was continued until today. So I get there today. The case dismissed was granted to the prosecution yesterday at the prosecution's discretion and per the request of the officer.
Nice.
It was a obstruction.
There you go. Very nice. Oh, man, that's fantastic. Well, congratulations. Did you get this in writing?
Oh, yes. I mean, the judge got off the bench, came over, sat next to me on the defense table, at the defense table, and gave it to me in writing and said it sweetly in my ear after arguing with this guy for months.
Holy, wow. The judge, he hand-delivered you a copy of the dismissal?
That's absolutely correct. They were actually in the middle of a trial. My trial was scheduled last month at 3:00 today. I get there. I get a notice to be in 1:45, so I get there. Between the notice and between the clock that's at the court, it was two different times. So I proceeded to ask what's going on. They said just go in and speak to the bailiff in the courtroom. I go in there having a trial at the moment, and the bailiff was tied up. Judge sees me, after dealing with me for over a year now, says, Mr. Sweeney, come straight ahead, come to the table. And then, he just comes off the bench and sits down next to me and, per the discretion of the prosecution, the case has been dismissed and I granted it.
Nice.
I said, okay.
That's fantastic. I hope, get that thing scanned and sent over here. I'd love to see that.
Yeah, I absolutely will.
You got to. I'm pretty sure we have something on the website for the last time you won, right? Didn't you send me the documentation?
That's correct. Well, that was the first time that I had actually had it thrown out, but then they recharged me, to do it again legally, and then they took me to trial, and I lost. Now I'm going to have to appeal that case, but yeah, same charges, different situation, different county.
Oh, okay, I gotcha. All right. Well, I'm sorry to hear that the other one got refiled, but well, if I could do something to help on appeal, I certainly will. Well, all right. Well, hey, we still have this big victory, and I have the paperwork from Jermaine that he beat 5 charges with a mistrial. So I'll get that posted. Hopefully, it won't be today, but it'll be by tomorrow. Well, maybe I can't get this video posted today. That's for damn sure. Maybe about 11 o'clock, because a 1 hour HD video is going to take my computer a few hours to render. But
right.
Maybe I can get Jermaine's document filed today. I'll post it today. I'll do that. So yeah, if you can send me yours, I'd love to get that posted. Man, that's fantastic. And you should call into the live. Well, we're not going to have a live broadcast on Saturday. I'm going to be traveling again. It'll be, but we'll have this. We'll have this audio that we can probably make available for the LRN broadcast, at least part of it, because I'll do what I can to get. Should be recording some segments with Scar tomorrow. So,
if I'm free Saturday, I can give you a call then too.
Well, I'm not going to be live on Saturday. So, if you want to contact me by email when you scan and email me the document, then I can let you know if when the availability is to record. Tomorrow or Friday, and we can use that for the show.
Okay. Sounds great.
Man, I hate to let you go. I'm going to try to get some other callers in, but that's fantastic. Just congratulations.
Not a problem. I'm glad I made it in to let you know how it went.
I saw you come up in the queue there. I was like, oh, okay, I remember. Okay, let's see what he's got to report. Great news. Fantastic. Thank you so much for calling in. I appreciate it, and looking forward to seeing the proof.
All right, will do.
Thanks again. Bill in West Virginia, there you go. Another success story on the No State Project with the paperwork hand-delivered by the judge. How can you beat that? We got a new caller in these last few minutes. We got area code 617. You're live on the No State Project. What's your name? Where you calling from?
Hi, Mark. This is Tony. I'm calling you from New Hampshire.
Tony from New Hampshire. Do you have a court proceeding or something?
Yes. We spoke earlier today. You suggested I call into the show. So I hate to follow that guy because my case couldn't have gone any worse than it did. But if you recall, I came to you urgently because a plea deal had been taken away, and so I was heading into court the following day. This is last Thursday, without really any defense from the published defendant. So I gave you the rundown on my circumstances, and you recommended that I file the 2 motions. The next day in the morning was already too late to do it that night by the time we spoke. And then opt to represent myself in the jury trial. I don't know if I said that earlier, but yeah, Thursday morning was the jury trial. And then have the public defendant standing as a standby counsel. So the main thing is exactly what you said, which was, focusing on the lack of evidence for the jurisdiction. Unfortunately, I'm pretty new at this and with your style, and so I very quickly ran into. So the judge denied the two motions that I filed, the Brady and I forget what the other one is called, that he had asked me to file. So the judge came out and denied those. He had to meet with me I had to meet with him because I needed to let him know that I was changing counsel to now defend myself, right?
Okay.
And we spoke, and he really tried to talk me out of it, tried to discourage me out of doing that. But the issue was that the public defendant, when I had asked her, what defense she would, what the strategy was, what defense she would be using, she said it was something like nullifying the conviction. So basically, what she was saying was we didn't really have a defense, and so we had to wait for the prosecutor to make her case to the jury, and then she would come up and try and sort of plead to the jury not to find me guilty, like what was saying. So anyway, it sounded really weak, which is why I was in such a panic when I was talking to you. So when we went into trial, in fact, before the jury even came, the judge totally locked me out of the jurisdiction questions. When I tried to push for evidence, when I tried to push for something that proves that the Constitution, that the laws that they were quoting, the code, as you say, applies to me, the judge would not hear of it. He just basically, ran me down and said that this is the law, and without a doubt, it applies. And so the prosecution doesn't have to, he was answering on behalf of the prosecution. And he said that that's not an argument. He warned me that that's not an argument that I can make in front of a jury at all. He said that I challenged the jurisdiction. He had denied the challenge, and so that issue was no longer on the table for me to bring up during the trial.
Okay, but it's still an element of the crime, and I want to point out for those listening, when he says without a doubt, he is coming out and telling you that this claim, this presumption is irrefutable, and you can't defend against it. That right there was your automatic reversible error because he's not allowing you to defend against an element of the charge.
So what he said multiple times, and I think the prosecutor commented on this as well, but most of the judge was saying this, they both did, is that the laws, the code applied to me because I was in the state of New Hampshire. Because I was physically in New Hampshire, that meant that those rules applied to me. So I pushed them, I tried to push them to show me that, show me the evidence, show me in writing. And they wouldn't do it. They just say that it doesn't need to show me anything, it doesn't need to prove anything, because the Constitution, because the Constitution gives him that right that if I was operating a car without a license in the physical location known as New Hampshire, then those laws applied to me.
Yet he can't present a single fact from the prosecution proving that that is true. So it's not just jurisdiction, it's an element to the charge. The charge being a code violation is only wrong because of the code. So these people who claim the code is not an element of the charge, you're saying that they're trying to get you to agree or to buy into this crap that they can prove a crime was committed without the code. And here, this is a very common thing, unfortunately. And no, it's not one of these things, yeah, Mark, it works in West Virginia, but it don't work in New Hampshire. No, these things go like this a lot of places, and we're not hearing anything very different. It sucks that happened, but I don't have much time here.
Sure.
Did you cross-examine the police officers? Or was that standby counsel that did that?
I did. Standby counsel did not do anything other than, consult when I needed some advice on the proceedings or something.
Okay.
And continue to push me to abide to the judge's orders and things like that. So it's like, which side are you on, right?
Yeah, well, cross-examination, did you ask the questions that I mentioned a few times here during the show? Did you ask him? Did you determine on your own that that the laws apply to me because I'm physically in New Hampshire? Did you get to ask that?
Yes, I did. I asked some of those,
okay.
But again, I asked some of those questions, but again, the prosecution would get to a point and object,
right?
And then the judge would call us. And sort of warn me that we already spoken about this and that this case, the question of jurisdiction has already been determined upon. And so, I wasn't to continue along that line of questioning. And whenever we tried, there was a couple of officers involved with the case. That's the position that the judge would take.
Well, what you have here, though, is a clear-cut denial of effective cross-examination. It's even if you give them a free pass on the issue of jurisdiction, give them a pass on that. It's an element of the charge. It goes to the police officer's prior testimony. Whatever happened on the stop is fair game for a cross-examination. So here you have two big due process violations where you were denied a fair trial. One, you've got the fact that the judge is treating a presumption from the prosecution as irrefutable. He basically said that it's without doubt. He's not allowing you to challenge it. Two, you've got a denial of effective cross-examination because you're asking a police officer questions going to his prior statements, directly to his prior statements. So it's no excuse for the judge to say, we've already decided that. You're talking an element of the crime and the competency and credibility of the witness, and the judge determined that before the witness ever took the stand? Come on, that's just not fair. So those are two big issues, and I would... at any time did the judge sustain an objection from the prosecution that it called for a legal conclusion and the witness was not qualified to testify?
Was that question, did the judge do that? Is that what you're asking?
Yes. Did the prosecution object to you're asking a question because it was that the witness was not qualified to make a legal determination or was outside the scope of his expertise? Did he make those objections to those questions?
No, he did not. Now, I may not have, again, pressed enough with the questions the way you laid it out. I honestly had very little time to practice on that, so I was definitely, my performance wasn't that good. But when I pressed the officers about making that determination, they, I believe, said that, same thing, that according to the law, the police code as they know it. Gives them the authority to be able to stop me and charge me.
But you can't question him based on that, on the determinations he made then. So denial of course. I have to go because I'm running out of time here myself. I appreciate you calling in. So at least no one can accuse me of cherry picking that we only discuss things like with Bill in West Virginia where it gets thrown out. But this is a very common thing that happens to us. You have two big issues on for appeal. So you can file to reconsider the decision, and then you can also file the appeal. So contact me off air, and I can help you with that. I do appreciate the call, Tony in New Hampshire. So will you contact me off air?
Yes, I will do that.
Okay,
Definitely.
appreciate it. All right, thanks, Tony.
Thanks a lot for all your help, Mark.
Oh,
okay.
I'm glad I'm able to help, and hopefully we can have a success story on your appeal.
Absolutely.
All right.
Thank you.
You're welcome. Tony in New Hampshire. And that is unfortunate that it has to this has to go to appeal. But like we spoke about on the last broadcast, yes, we are building our appeal not because we lose most of the time, but because it's a smart thing to do. And you're back. And plus, if you're doing that and you're pushing the judge to a point where he's making errors like that, requiring no prejudice to get reversals, like denial of effective cross-examination, then chances are you're going to not have to appeal in the first place because you're making effective challenges that, like in Casey's situation, congratulations again, it was effective at having the prosecution back off. Hey, my name's Marc Stevens. We'll have this video up on my channel and also at markstevens.net. If you disagree with what was presented here on the show today, you're more than welcome to contact me at markstevens@mail.com. Skype is FrankRizzo3, and you can post on markstevens.net and also on the forum. And we won't be live this Saturday, but we should have new material. So definitely check that out. Again, the website, markstevens.net. And until next time, salud.